Hello, welcome to the Deportation section of the UOV Justice Center website. Glad to have you. Disclaimer: the information provided on this site is not legal advice, but is provided for informational purposes only. If you are in need of legal advice, we advise you consult with an attorney. Overview: deportation is the formal and lawful removal of an undocumented individual from the United States for violating an immigration law. As mentioned in the immigration page, violating certain laws while being documented or undocumented can lead to deportation. Individuals who come to the United States without travel documents or with forged documents may be deported without an immigration court hearing. This would be an expedited removal, whereas going before a judge would be a longer process known as removal. Where do deportation cases take place? Federal courts handle all cases having to do with immigration. This includes deportation cases. The deportation process. Step 1. Before being removed and following the formal procedure, you may be able to leave the United States on your own. This is known as voluntary departure. The deportation process. Step 2. During the removal process, an undocumented individual may be held in a detention center prior to receiving a trial date or deportation. If you are in need of locating an ICE detention facility or locating someone who has been detained, you can use either of the links that will send you to the ICE detention facility's webpage or the ICE Online Detainee Locator System. The deportation process. Step 3. Once being held in a detention center prior to trial or deportation in an immigration court will then hear the related case. During this stage, a judge will rule whether the deportation will proceed or not. If the deportation is scheduled to proceed, the receiving country of the person being deported must agree to accept them and issue travel documents before the United States Immigration and Customs Enforcement carries out a removal order. The deportation process. Step 4. If you are undocumented and facing removal, you may be eligible to adjust the status process to request a green card and become a lawful permanent resident. This can usually be completed by having a family member complete a petition or go through requesting asylum if you fear danger or prosecution in your home country. Appealing deportation. In the United States, you may appeal certain deportation rulings. In most cases, an appeal is allowed depending on the circumstances. For example, if your removal is based on facts that you have committed a crime, you can appeal in order to convince the judge that you are innocent. Similarly, if you have already been convicted of a crime or have a criminal record, an appeal may not be allowed. Appealing deportation continued. In order to appeal, the appeal must be submitted within 30 days of receiving the deportation notice with the Board of Immigration. You can also request a waiver of removal. This is only available for non-criminal related removal grounds. You can also request a cancellation of removal, which can be used in case you have been in the United States for at least 10 years. Applying for readmission after deportation. If you have been deported or removed, you may be able to file an I-212 form to apply for readmission to the United States. Form/templates. I-212 is an application for permission to reapply for admission into the United States after being deported or removed. In order to complete this form, you will need to verify your status, such as proof of citizenship, criminal records if any, and your contact information. You can access the form for free on the USCIS website along with instructions on how to fill out the form. Once the form is completed, you will have to mail it in to the corresponding USCIS lockbox facility, which varies by state. This has been an overview of the deportation section of law on behalf of the UOV Justice Center. We thank you for your time and hope this information is helpful in your legal matter.